Article 22 says protection against arrest and detention in certain cases. This provision is extended to both citizens and non-citizens. It provides certain procedural safeguards to people in case of an arrest. It is pertinent to note that this provision is not a fundamental right against detention and arrest. This right aims to prevent arbitrary arrest and detention. This provision does not include the people arrested under preventive detention laws and enemy aliens. This article further provides the following article 22 subclass 1. This provision states that any individual who is in custody has to be informed as to why they have been arrested. Also, they must not be denied the right to consult a lawyer. Article 22 subclass 2 says, this provision states that the arrested individual should be produced before a judicial magistrate within 24 hours of their arrest. This provision further states that no individual who has been arrested can be held in custody for more than the period fixed by the judicial magistrate. Right against exploitation, this comes under Article 23. Prohibition of trafficking in human beings and forced labor. This provision is further divided into the following Article 23 subclass 1. Human trafficking and beggar and other such forms of forced labor are prohibited by virtue of this provision, and any kind of violation of this provision shall be a punishable offence under the law. Article 23 subclass 2 says, nothing in this article shall prevent the state from imposing compulsory service for public purposes, and in imposing such service, the state shall not make any discrimination based on the grounds of religion, race, caste or class or any of them. This provision not only protects citizens from the state but also from private citizens. Certain laws were passed by the Parliament with regard to this provision. They are Bonded Labour System Abolition Act 1976 and Suppression of Immoral Traffic in Human and Girls Act 1956. Article 24 says prohibition of employment of children in factories, etc. This provision states that no child below the age of 14 years must be employed to work in any factory or mine or engaged in any other such hazardous employment. This provision prohibits the employment of children below the age of 14 in any hazardous industry or factories or mines, irrespective of any exceptions, but the employment of children in non-hazardous work is legally allowed. Certain laws were passed by the Parliament with regard to this provision. They are the Factories Act 1948, the Mines Act of 1952, the Child Labour Prohibition and Regulation Act 1986, Child Labour Prohibition Regulation Amendment Act 2016, etc. Now we move on to the right to freedom of religion, Article 25 to 28. Article 25, freedom of conscience and free profession, practice and propagation of religion. This provision guarantees the freedom of conscience, the freedom of profess, the practice and propagate one's religion to all citizens. However, the said freedoms are subject to public order, health and morality. This article further mentions that the state can make laws to regulate or restrict financial, economic, political or other secular activities relating to religious practice. It further allows the social welfare and reform or opening of Hindu-religious institutions of a public nature to all sections and classes of Hindus. Article 26 says, freedom to manage the religious affairs. This provision states that subject to morality, health and public order, every religious denomination has the following rights. The right to form and maintain institutions for religious and charitable intents. The right to manage its own affairs in the matter of religion. The right to acquire immovable and movable property. The right to administer such property according to the law. Article 27 says, freedom as to payment of taxes for promotion of any particular religion. As per this provision, no taxes shall be imposed on such proceeds which are directly used for the promotion and or maintenance of any particular religion or religious denomination. Article 28 says freedom as to attendance at religious instruction or religious worship in certain educational institutions. This provisions enables the establishment of education institutions that are maintained by religious groups to disseminate religious instruction. Now we move on to the cultural and educational rights. Article 29 says protection of interest of minorities. This provision of the Constitution aims to protect the interest of minority groups. Article 29 subclass 1 says this provision states that any section of the citizens residing in India having a distinct culture, language or script have the right to conserve their culture, language and script. Article 29 subclass 2 says this provision mentions that the state must not deny admission into educational institutions maintained by it or those that receive aid from it any person based on the grounds of race, religion, caste, language or any of them. Article 30 says right of minorities to establish and administer educational institutions. This right is provided to minorities to form and govern their own educational institutions. This is why the said provisions is also known as the Charter of Education Rights. Article 30 subclass 1 says, this provision states that all religious and linguistic minorities have the right to establish and administer educational institutions of their choice. Article 32 subclass 2 says, this provision provides that the state, when granting aid to education institutions, shall not discriminate against any education institution based on the reason that is under the management of a minority, whether based on a religion or language. Article 31 provided that no person shall be deprived of his property save by authority of law. It also provided that compensation would be paid to a person whose property has been taken for the public purposes. Article 32 says right to constitutional remedies. The Constitution guarantees certain remedies if the fundamental rights of the citizens are violated. The state does not have the power or authority to infringe upon or curb the right of any individual. In case these rights are violated, they are aggravated, the individual can approach the courts. They can even directly approach the Supreme Court of India, which can issue writs for the enforcement of fundamental rights. There are 5 kinds of writs that can be issued by the court. They are habeas corpus. The term habeas corpus means to have the body of. As per this writ, the court has the authority to call upon any person who is being detained to assess the legality of their detention. Certiorari. The term certiorari means to be certified. By the virtue of this writ, a higher court reviews a case that has been tried in a lower court. It is basically employed to seek judicial review of a decision given by a court or a government authority. Next, prohibition. The writ of prohibition is issued by a court to restrict or prohibit the lower courts, tribunals and other such quasi-judicial authorities from acting beyond their legal authority. It is employed to check inactivity, whereas the writ of mandamus checks activity.